All right, I call cause number 10,843 for the case that is styled the State of Texas versus Adrian Villa. This is a plea hearing wherein the plea papers that have been handed to the court indicate that the defendant desires to enter a plea of guilty to the charges in the indictment and to do so pursuant to a plea agreement between defense and state. This plea hearing is being conducted by remote video teleconferencing technology, and it is also being live streamed on the court's YouTube channel, all to comply with Texas Supreme Court orders and rules and directives from the Office of Court Administration. Since it is being broadcast in this virtual capacity, I also announced that all participants and those who are observing either on YouTube or through the Zoom protocol are expressly prohibited from recording any portion of this proceeding, whether using the record function of those virtual venues or whether they're making copies by photographic or other means. That is expressly prohibited. The court reporter for this court is the only exception. He is making a transcription and recording of this proceeding just like he would do if we were in a live in-person hearing. We are live, but not in person. We're doing it by, as I mentioned, the remote video teleconferencing technology. With those announcements, I call upon the state and ask, is the state ready to proceed?
The state's ready, Your Honor.
And Ms. Brooks, on behalf of the defense, is the defense ready to proceed?
Defense is present and ready, Your Honor.
Are you Adrian Villa?
Yes, sir.
Mr. Villa, an indictment has been returned into this court charging you with a third-degree felony offense of possession of a prohibited substance in a correctional facility. As mentioned, that is a third-degree felony as alleged. You have the right to have this indictment read out loud to you here in open court, even by virtual court. Do you wish to have someone read the indictment out loud to you?
She read it to me, but I mean, I'm all right.
Okay, does that mean
No.
it's not? No, okay, that's what it means. In the indictment that's been read out loud to you and that's been shown to you when you were arrested, is your name spelled correctly?
Yes, sir.
And is Adrian Villa your true and correct name?
Yes, sir.
Mr. Villa, understanding the charges to this indictment, to the charges in this indictment, how do you wish to plead to those charges? Guilty or not guilty?
Guilty.
Do you understand that you do not have to enter a plea of guilty? You have the absolute right to enter a plea of not guilty. And further, you have the right to not have it held against you or used against you just because you might exercise that right. Do you understand that?
Yes, sir.
You also have the right to have a minimum of 10 days notice of the charges against you. I'm not certain, I didn't look all the way through the file, whether you've actually had 10 days notice or not. I think that you have, but just in case, whether you have or you have not, I will grant to you additional time to prepare if that's something you need or wish to have. You also have the right to have a jury trial, which is true even if you enter a plea of guilty, as you've indicated you wish to do in this case. Do you understand you have the right to a jury trial?
Yes, sir. Yes, sir.
I have been handed a document entitled Waiver of Defendant, which has what purports to be your signature, Adrian Villa. It says you're giving up the opportunity to have more time to prepare and you're giving up the right to a jury trial. Did you sign that document?
Yes, sir.
And did you realize you were giving up the opportunity to have more time to prepare, as well as the right to a jury trial when you signed it?
Yes, sir.
And is that what you still wish to do?
Yes, sir.
Ms. Brooks, your signature is also on this document. Is that evidencing your joinder with your client in the waiver of these rights?
Yes, sir.
And Mr. Smith, your signature is also on this document. Does that evidence the state's joinder in the waiver of the right to a jury trial?
Yes, Your Honor.
All right. I announce that I will accept and approve these waivers, and we will proceed. Mr. Avila, there are other rights and admonitions I need to cover with you. Let me begin by discussing the range of penalties that exist for a third-degree felony such as is charged in this indictment. The range of penalties for a third-degree felony runs from not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice, the institutional division. And a third-degree felony also carries the range of the possibility of a fine in the range of penalties. And if a fine is it's assessed, it could be in any amount not to exceed $10,000. And then there is an enhancement paragraph alleged in your indictment, which, if you were convicted of this charge, and if the enhancement paragraph were proven to be true, then the range of penalties faced under those circumstances would run from not less than 2 years to not more than 20 years in the Texas Department of Criminal Justice institutional division, with the same possibility of a fine, which could be imposed, and if so, in an amount not to exceed $10,000. Do you understand those are the ranges of penalties you face under the indictment in this case?
Yes, sir.
Now, I have been handed the plea papers, which include a plea bargain agreement document. Let me advise you that I am not required by Texas law to follow that plea bargain agreement. I am required to let you know if I'm going to follow that agreement or not, because if I decide for whatever reason not to follow the plea agreement, then the law would recognize another right in your favor, which would be the right to withdraw your plea of guilty. And if so, we would just start all over, and nothing you have said today, such as pleading guilty, nothing you have signed, including a stipulation of evidence, none of that would be used against you as we went forward with your case. The other side of that coin says this, however: if I do follow your plea agreement, you will be bound by the terms of the plea agreement, and you will not be able to get out of those terms, even if you later change your mind, even if you wanted to appeal, you could not change the plea bargain agreement provisions, and you could not appeal. And I say that even though ordinarily there is a right to appeal in Texas, even from a plea bargain agreement, except if a part of the plea agreement itself says you're giving up the right to appeal as a part of the agreement, then that provision also means what it says, and you cannot change that provision. So if I follow your plea agreement, you cannot appeal at all. Do you understand that?
Yes, sir.
All right. Then there are other matters I need to cover, and so let's proceed. I start by asking, are you a citizen of the United States of America?
Yes, sir. Yes.
Where were you born?
In Nolan County.
Texas.
Yes, sir.
Okay. My next question asks, do you consider yourself presently to be mentally competent?
Yes, sir.
Do you know what's going on in these proceedings?
Yes, sir.
Have you been able to discuss the charges against you, as well as the facts that may surround those charges, with your attorney and get her advice about what the law is as it applies to those facts, or the facts apply to the law in your case? Have you been able to do those things as well?
Yes, sir. Yes.
Ms. Brooks, do you believe your client is mentally competent?
Yes, Your Honor.
I accept that representation, and it's obvious to the court that Mr. Villa is mentally competent, and so I make that finding. Mr. Villa, my next question asks, are you satisfied with the legal representation you have received in these matters?
Yes. Yes.
All right, sir. Let me tell you why I asked that question, because I'm not trying to tell you that you wouldn't be or shouldn't be. I've just asked the question so you would have a chance to tell me if you were not satisfied. If you thought the work was somehow deficient or legally ineffective, my question gives you the chance to tell me so that I could fix any deficiencies or get any legal ineffectiveness corrected. And by giving you that opportunity, that necessarily means you cannot wait and expect to be successful by waiting until some later date to say your lawyer didn't do a good job. Now's the time to raise that while I can still get any problems, if any exist, corrected. Do you understand that?
Yes, sir.
And understanding that, are you still telling me you're satisfied with the legal representation you've received in these matters?
Yes.
The next question deals with your decision to enter the plea of guilty in this case. The law says I must be satisfied that the decision to enter a plea of guilty is your decision, freely and voluntarily made by you. And so I ask a series of questions to help me ascertain that. First, has anybody threatened you or forced you or tricked you or in any way tried to make you enter this plea of guilty when you would not otherwise do so?
No, sir. No.
Has anybody paid you anything or promised to give you some benefit just to get you to plead guilty to these charges when you would not otherwise do so?
No.
Are you telling me then that you're pleading guilty to these charges because the truth is you are guilty of these charges and that's the only reason you would plead guilty to such a charge?
Yes, sir. Yes.
And to the enhancement paragraph, the second paragraph in the indictment, alleging a prior felony conviction, to that allegation, how do you plead to that one? True or not true?
What's that adding it here? What do you mean? Yeah, true.
Well, let me repeat it to make sure you understand. I realize by doing this on Zoom, sometimes the sound quality gets interfered with. So I was asking about the second paragraph in the indictment in your case, alleging a prior conviction of a felony. And my question is that allegation in that indictment, that second paragraph, is it true or not true?
Oh, true.
All right, sir. I believe those are all the questions I have at this time. Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in this case.
No objection, Your Honor.
Mr. Villa, the stipulation of evidence that's been handed to me covers some other matters that I need to discuss with you. One of them is to discuss another right that seems to fit in the discussion right here. That's the right to confront the witnesses against you. The right to confront the witnesses against you means you have the right to require the state to bring their witnesses into court so that you can hear them and see them, even if it's by virtual presentation. And thus you can assist your attorney in cross-examining those witnesses. But this stipulation of evidence says you're giving up that right. Thus you're telling the state they do not have to bring their witnesses into this court at this time in your case. Did you realize by signing the stipulation of evidence, you were giving up the right to confront the witnesses?
Yes.
The stipulation also says you're giving up your right to remain silent and you're giving up your right to be free from self-incrimination, which is the right to not be forced to give evidence against yourself. And instead, by signing the stipulation, you are incriminating yourself, because the stipulation is a judicial confession wherein you are admitting that you committed the offense alleged, as well as admitting that that prior enhancement paragraph is true. Did you realize that you were admitting these things when you signed the stipulation of evidence?
Yes.
All right, State's Exhibit 1, the signed sworn stipulation of evidence is received as evidence in this cause.
State rests, Your Honor.
Defense rests, Your Honor.
The state closes.
Defense closes, Your Honor.
All right, then I announce in cause number 10,843, style the state of Texas versus Adrian Villa, that based upon the plea of guilty entered by Mr. Villa, as well as the stipulation of evidence which was entered into this court, I find that Mr. Villa is guilty of the third-degree felony offense of possession of a prohibited item in a correctional facility, just as is alleged in the indictment in this case. I also find that the enhancement paragraph alleged is true, based upon the stipulation as well as the plea by Mr. Villa. Mr. Villa, having announced the judgment in this case, do you know of any legal reason why sentence should not be imposed at this time?
No, sir.
Then following, you know what? I did that a while ago. I apologize. Let me do this. Let me back up. And let me make sure the plea agreement that you have entered into, that I understand that plea agreement the same way you do. The plea agreement says you will enter a plea of guilty to this charge, as you have done. It says that's going to result in a 8-year sentence to the penitentiary, with a fine being imposed in the amount of $1,500, as well as court cost in the sum of $290, and reimbursement fees being ordered in the sum of $660. It also requires, or says, that probation will be required as a part of the plea agreement in the sum of $180. The plea agreement says that you will waive your right to appeal, as we discussed earlier, Mr. Villa. And it says that you will also be entitled to 130 days time credit against your sentence. Now, that's my understanding of the plea agreement in your case. Is that the same as your plea, as your understanding of the plea agreement in your case?
Yes.
All right, I announce that I will accept and follow your plea agreement. And so I further announce, as I was doing a moment ago, that I find Adrian Villa in cause number 10,843, based upon the plea agreement and the stipulation of evidence and the plea of guilty, that Mr. Villa is guilty of the charge of possession of prohibited item in a correctional facility as alleged in the indictment, and that the enhancement paragraph alleged therein is also true. And now I was getting to the point of asking you, Mr. Villa, if you know of any legal reason why sentence should not be imposed at this time.
I shouldn't.
Do you know of any reason why I should not go ahead and announce and tell you what the sentence is at this time?
No, sir.
Then, following your plea agreement, as I announced I would do, I hereby sentence you to serve 8 years confinement in the Texas Department of Criminal Justice, the Institutional Division. I order you to pay a fine of $1,500 as specified in the plea agreement. I assess court costs in the sum of $290 and order you to pay reimbursement fees totaling $660, as well as to pay a $180 restitution amount. I also follow the plea agreement and grant to you, Mr. Villa, time credits totaling 130 days. That's the judgment and sentence in this case. Mr. Villa, do you have any questions about the judgment and sentence or anything about this proceeding?
No, sir.
Then Mr. Villa, your thumbprint is going to be required on this judgment and sentence. Someone from the sheriff's office from there at the jail will present this judgment to you and obtain your thumbprint. I might have said fingerprint, but I mean your thumbprint, and to fix it to the judgment. With that, we will be in recess. As you go, finally, Mr. Villa, one last opportunity. Do you have any questions that you have at this time?
No, sir.
Thank you, sir. We're in recess.
Your Honor.
Yes.
May I tell Mr. Villa something real quick?
You may.
Okay. Mr. Villa, I talked to your brother and he said he'll be picking up your stuff this week.
Okay, thank you. Stay sweet.
Thank you. Kevin, are you going to get a copy of the judgment for his signature?
Yes, sir.
Okay, thank you. We're in recess.
Your Honor, may I be excused?
You may be excused.
Thank you.
I'll have to go get the paperwork from the courthouse and bring it.